Hi, my name is Doug Marks, and today I'm going to answer the question, what do you include in your CCPA compliance checklist? CCPA compliance, California Consumer Privacy Act compliance, really looks different in different companies. It's really hard to have a checklist, but I do have a questionnaire that guides me through issues with potential clients. So I don't necessarily just have a checklist, but depending on their answers to questions in my questionnaire, which I typically will do, instead of sending them the questionnaire, I'll just refer to it myself. We'll get on the phone with a CFO or a CIO, depending on whoever is in charge of the data. So usually I have two members from a company that are on the phone with me, and we're working through this. So really a one size fits all checklist or a computer program. I see some people say, yeah, we have software that works you through it. I'm just like, yeah, I don't think so. Everybody is so different. And depending on the answers, you're going to go down different avenues. So yes, there is a checklist, but it's built into my questionnaire. So when I bring on a potential new privacy client, the first thing I do is dig into the details of their business. I really need to understand who they are, how they're operating, what data they have. But, if you just ask, I find anyway, if you just ask about the data, then you're only going to get about half of the story. You need to talk about their business and who are their customers? Who are their clients? Where do they get their data? How do clients pay? Do they sign agreements? Are they click through negotiated agreements? How do they deal with their customers? Every company is just so different. One of my clients is a genealogy software company. They do archiving of data, indexing data, newspapers and other things. And so you have this huge set of questions. What data is public? What is private? If it's in a newspaper, what if somebody wrote their personal reflection? How much is public on the website? Is it behind a paywall? What is personal data and what is not? I've got another client that provides software as a service to professional sports franchises. So their tool helps the franchises manage their interactions with their fans. And so there's just a ton of personal information of their fans that's being processed by my client's platform. So you can just see that you have a different set of questions, different set of concerns and regulatory issues that we need to think through with every company. So the third thing I do is really dig into the kinds of data they've collected or they do collect. What data do they get from their clients? How do they register a client? What about their clients? If the clients have customers and other users, what kind of data do we get from them? How do we get data to do marketing? Are we participating in co-ops? Things like that. So that's the next question I ask, and we just dig in based on whatever they answer to know how it relates to the CCPA. Then what I do is dig into what they do with the data. Once they collect it, do they process it directly? Do my clients have sub-processors or service providers? When do they delete it? When do they archive it? What regulations apply to their obligations to keep data? I've got one client that is an educational software platform, and so their clients or their customers are universities who will use my client's software to record presentations. So the professor can make notes in the video as you're going and come back and look at it. Well, so you've got FERPA. And if that same tool were used by a younger set of students, then you would have Child Online Privacy Protection Act issues. So you can see there's just a number of things you need to dig into on each client. And when we get that far, that's when I usually ask about the CCPA specifically. I start asking them whether they have 50,000 data subjects, whether they have $25 million in revenue, whether a majority of their revenue comes from the sale of personal information. And I like to wait to ask that question until I've gotten the juices flowing a little bit, because I find that, people don't know what to expect. They get on the phone or on a Zoom call, however we do it, and you really need to get the juices flowing on what they're doing before they can start answering these other questions. And you'll also notice that, including in this video, and I do it in my interviews with clients as well, I don't really get exact about the terms usually. I mean, I understand the terms, whether it's personal data, personal information. There's different terms that are being used by different states and in the GDPR. And I don't really get too concerned about being exact. And that's on purpose, just because everybody has different definitions. And I don't want my clients to start to think, well, does that qualify as personal data? I want to let them just let the thoughts flow. And then I'll do the determining whether it's covered and how it relates. So you'll notice that in my videos also, I don't get overly concerned about what terms I'm using, usually. So then if they aren't covered, I ask, or we kind of drill down on whether they want to get compliant anyway. And typically when my clients find out what is involved in getting compliant with CCPA, they say, well, let's just do it. Even if we're not compliant, or even if we're not required to be compliant, we likely will be within a certain, number of years. And so they usually do. And they'll start asking, well, what will it cost? And that depends, but it's usually about $4,000. My hourly rate right now is $230 an hour. And it usually is less than it's between a 15-hour and a 20-hour project to get through all their documentation. And what I do is I tell clients, I will either review or draft your terms of service with your clients or your customers. I'll draft a website terms of use just for people who are coming to browse their website. I'll draft a privacy policy or revise theirs if they have one already. If they have an end user license agreement, I'll draft that for them. I'll put together a data processing agreement for them and a security measures document. And then I'll walk them through how they respond or how they comply with the CCPA in terms of specific items they need to do on their website, disclosures they need to make, and things like that. And then also guidelines for verifying and responding to CCPA requests. So, when it comes, $4,000 is real money, but it's not as much as some people are expecting quite often. So, assuming that we're going to move forward on CCPA compliance, then I dig into the questions related to the privacy policy. Under the CCPA, you have to disclose where you get your data and what you do with it. Over the years, I've worked with a lot of clients that have to comply with GDPR and CCPA, and I've built several templates for different types of clients that have different operational needs. So somebody might need to be CCPA compliant, but not GDPR compliant, or vice versa, or maybe neither one. And so I've got different templates for different needs. My general approach, and I recommend this to pretty much everybody, I say, listen, the state of regulations is in flux. And the trend is definitely for more states and more countries to require privacy compliance with new regulations. And so I've identified several privacy principles. These are things that are general across the board. Whether you're under GDPR or CCPA, you're going to want to be able to allow, if you're a state or a country, you want your citizens to be able to see what's being collected about them. You want them to be able to correct faulty information. You want them to be able to delete information about them if they don't like it being out there. You want them to, you just have all kinds of different principles that I've identified and built into the privacy policies. And so I usually tell clients, listen, if you can comply with the principles, then as new regulations come out, chances are you'll already be compliant with whatever happens. So if we can stay ahead of it in the long run, it's a lot less expensive to stay compliant with privacy requirements. One of the things that I do address in my privacy policies, even though they may not need to be, is this lawful basis, which is a concept that is required under the GDPR. I always address that. It doesn't cost us anything, and I think it's going to be something that'll be used more often in the future. But the types of data that I dig into are, and the titles I use are registration data. I don't want to give away all my secret sauce here, but when I talk about registration data, we're talking about name, login credentials, email address, contact information, that kind of stuff. Second category would be engagement data. What kind of data are you using your platform to process? And, one of my clients provides a software tool to dealers, car dealers. And so, they manage all of the interactions with dealers and their customers. So the sale and also any maintenance that's done when they bring the cars back. So engagement data would be all the data about what maintenance was done, what the sales price was, how many visits there were, stuff like that. Payment data would be credit card information. Most people are tokenizing that and not actually collecting payment data, but there is some. Usage data is another category that I use. And that's basically, how are people using the website? That's something that my clients want to know. And so we disclose what data we're collecting in terms of usage of the website. Then there's always special data considerations. I always need to add another category or two or three. I've got a client that has written a software tool that offers tires as a service. So you sign up for their service, and they've got people who will come all over the country. They will come and install new tires every so often, or when you get so many miles on your car, they'll come and bring you the new tires, and they'll install them at your home, put them on at your home, things like that. There's just such a broad array. There's always some kind of data that you need to address separately. Another client that I'm working with connects mortgage companies and insurers. So these lenders, when a buyer is coming to buy real estate, then the lenders can use my client's tool to connect via an API to different insurers so they can verify that the person has coverage on their mortgage. So we need to address who owns the data, whether it's personal data, how long it will be kept. And so it's just different in every case. So once you know what data we're collecting, what we're doing with it, there are typically some changes that need to be made. And then you have just the disclosure requirements under with the CCPA compliance requirements, it requires you to tell people what you're doing with what data you have, how you got it, what you're doing with it, and you have to do that by category. When you're selling data, there are extra requirements under the CCPA. You have to give data subjects the right to opt out of the sale of their data. And you've got to inform them that you're selling their data. And I'll address that in a separate video of what compliance needs to be, or what compliance efforts need to be made for that. If you're not selling data, you don't have to give data subjects a right to opt out, but you still have to tell them generally what data you're collecting, and that's in your privacy policy. You've got to give them a web form so they can ask you to tell them specifically what data you have about them. And you have to give them an opportunity to delete and correct and export their data. So that's really getting into the checklist part. One of the items on the checklist, and the most important probably, is the link that you've got to have on your homepage for California privacy. You've got to have a link that links to your privacy policy, but not just the privacy policy. It needs to link to the part of the privacy policy that specifically addresses California consumer rights. And I've got a checklist that I hand to clients after we're done with our interview that says do this, that, and the other. All these things that I'm going to talk about here. So in that section of the privacy policy, there's specific language where you have to disclose how they can make requests under the CCPA. So, when I talk to clients, I usually suggest that they do the web form. You've got to do the web form. I suggest that they do both an email address and an 800 number. There are exceptions. The 800 number you don't have to have if you're dealing directly with the data subjects and you operate only online. But that's under California. What's going to happen when New York passes their law? I just say, as long as you're doing it, let's get it all covered. So the next thing I ask them about is service providers. Who are you using as your service providers? They might be processing information for you. Maybe you're offering a SaaS platform, but your SaaS platform is on a cloud provider, Azure or, Google or AWS. So they're your service providers, and you need to ensure that they're managing data consistent with the requirements of the CCPA. And that needs to be in writing. So I typically go through a list. Okay, who are your sub processors? Who are you using to contact and communicate with your customers? Are you using HubSpot? Do you have a CRM? We work through all the flow of all the data that they get, how they interact with customers. And that needs to be disclosed in your DPA typically. The specifics anyway. One of the things that we talk about is verification. When somebody calls in and they make a data request under the CCPA, or they send an email or use your web form, and they say, hey, I want to know what information you've got about me, you need to verify that they are who they say they are. You can't have Johnny calling up and getting Billy's information. So typically the way that verification is done is by having them log in. And you have different requirements, two-step checks. And so we can work through how that happens. And then we're getting close to the end here. The security measures that people need to take. And we'll talk in a later video about the penalties and the remedies if there is a hack. But there are two types of security that companies need to think about: organizational and technical. The organizational security is things you can do for best practices, like having security badges, You can't have passwords on sticky notes under your desk. When somebody leaves the company, their credentials get deleted or canceled immediately. All kinds of things like that. And I've got a checklist that I give clients for that. The technical security measures are things that you do, in essence, to prevent hacking. And your cloud provider is going to do a lot of that. Your service providers will do a lot of that. SOC 2 is also part of that effort. And that's one thing that I don't usually, as an attorney, I don't dig into the technical security side very much, other than to help them understand what it is and that they need to do it. So that's pretty much it. I mean, every interview is going to be different. But when I get to the end of the interview, then I will typically offer to work through all of their agreements. It doesn't do any good to just put up a privacy policy and say you're done. You need to make sure that your terms of service work together with your privacy policy and your data protection agreement. You need to have a set of terms of use for your website, for just browsers. You need to have the verification and compliance guidelines so employees can work through things. And I typically try to just make one big package that incorporates all those. Once they get that, then we work through all the changes that need to be made. But once they implement everything, then they're good to go. All right. Thank you for listening. And if you liked the video, then please subscribe and like the video. And I'll be answering another question soon. Thank you.